So hello friends, today we are going to discuss about trademarks and the relevance of trademarks in today's world. The importance of trademarks can never be overemphasized. In fact, whenever somebody wants to start a business, the first thing that he should actually be looking at is a trademark, because that's the first thing, that's the first start point for any person, because a brand is built on a trademark. The business is known by his trademark, so therefore trademarks are extremely important. What I will do is I will divide our discussion today into three parts. The first is I will talk about trademark registration, the importance of trademark registration, and thereafter we will go into how a trademark is filed, and subsequently we will talk about infringement. So here we go. Now when we talk about trademarks, what is a trademark? Trademark can be anything. It can be a word, like Godrej is a word, McDonald is a word, so it can be anything. It can be the name of a person, so Birla is the name of a person, or Tata is the name of a person, so it can be the name of a person as well. It can be a logo, like you have the Nike or the Adidas, they have certain logos, or you have Haldiram, which is written in a certain stylized manner, so even that is a logo. Or it can be a number. So if you take, for example, this is a very odd example, but an example could be 8 p.m. for beer or whiskey, and you have other numbers like 999, 97, or you have those medical shops 98.4. So those also could be registered as trademarks. So even just a number could act as your trademark. It entirely depends on how you brand yourself and how you brand your product and your process. Once you have adopted a particular trademark, you think that this trademark will work for my business, then you must proceed to file for registration of that trademark. Now what is important is, while you may have a trademark for your product, you must distinguish between the two. One is having a trademark for your product, and the other is to have a trademark for your name of the business. So in the sense that, for example, I can give you an example, like you have Maruti Suzuki. So Maruti Suzuki is the name of the company. The company has got several brands within that main company. So within that main company there are several other brands, like you have Alto, you have Desire, you have so many other sub brands within the main brand. So one thing that you can do when you think of starting a business is to have the name of your company, like your name of the company can be Purple Yogi Private Limited, and Purple Yogi Private Limited will produce several products, and those products could be any product, like Sizzle, and it could have so many other products. So all the other brands, the sub brands, will be brands which fall within the main brand of your company. So your company will have one name that can of course be registered, because Purple Yogi as a trademark can be registered, and then you will have sub brands within that, and even those would be registered. Now once you have adopted a trademark, before you adopt a trademark, once you have thought of a trademark, the important thing to do is to search whether this trademark is actually available to you. Because I may think that Purple Yogi is a very good trademark for me, but have I ever checked whether someone else has actually filed and actually got a trademark for Purple Yogi? It may be possible that because there are products which are not available in the market, and you are not a person who knows everything about everything in India or even the world. So there may be somebody with the name Purple Yogi, and perhaps he would have registered himself as a company in Gujarat, and you may perhaps not be aware of it. So therefore, before you adopt your trademark and before you start your business with that trademark, the good thing will be to go for a search. So very important is to conduct a search and then to find out as to the mark that you have actually thought of, is it registered or not? If it is already registered, then there is no point for you to proceed with that mark. You must think of a different mark. But on the other hand, if you find that no, this person, no one has registered this mark, then it is always good for you to go for registration. Now, I can give you some examples. Like we had someone who came to us and he says, I want to register homestay for, providing services for bread and breakfast. So, you have those people who will, give you an accommodation for a day or a couple of days, and small little minor hotels which you can find in various small locations. So homestay was one such mark which they had thought of. But ultimately they found that there are other people who have registered themselves as homestay. There was someone who had registered himself as homestay, and it was registered since 2005. So since 2005, if someone has registered himself as homestay, then there is no scope for you to also have a mark homestay and then insist that you should get the registration. In fact, the registry will never grant you this kind of a mark. So they changed themselves and they called themselves as Home Club. Home Club was not registered by anyone, and therefore they started to register the mark. Similarly, we had another case which came to us. Someone said they wanted to start the business of serving tea. They wanted to have all kinds of tea under the roof. You have normal tea, the cutting chai which you have. Then you have the Darjeeling tea, the green tea, and all sorts of tea. So on those lines, they wanted to have the mark Kappa Chai. So I told them that they must go for a search. And when they did the search, they found that there is someone who has registered himself as My Kappa Chai in 2001. Now, because he has already registered himself as My Kappa Chai in 2001 and it's a registered trademark, then obviously, you can't have a mark called Kappa Chai. You cannot, just because that mark is My Kappa Chai, you cannot break it into pieces and say, I will now have a mark which is Kappa Chai. That's not allowed. So they had to change their mark. Fortunately, there was no litigation in this because it was just that they had come to me and they asked us for advice. So we advised them that you should change the mark. They changed the mark and they started with Hot Chai. Hot Chai, CHAY. And this way they started to, start their business. There was no one who had registered Hot Chai, CHAY. And then they managed to continue with their business. So therefore what I am trying to say is, before you adopt any trademark for your business, the search is very important. If you don't do a search, then you might just land in trouble, because you will always find a lot of people who have registered their trademarks. Maybe they are not using the trademark, never mind, but the trademark is there. Nevertheless, so if the trademark is there, and even if he is not using the trademark, you have to go and first get it rectified, but you have no right to start using the mark. It may be another thing that he is not using the trademark for his business and someone has registered it, it is there on the register, but you can't use it because someone else has already registered it. And it's not difficult, you can always come up with a new mark. So it's very important for you to do a search. Otherwise, you will launch a product, you have a product, you will launch the product, and ultimately you will find that, there is no use because there is a litigation around it. There's someone who has registered it, and that person is coming after you saying that, look, why have you copied my mark? There are issues of that nature. Next comes the issue as to whether we should actually register a mark or not. Now, this is a very important consideration. I would suggest that you should register the trademark, not for any other reason. Actually, whether you register or not, the law says that you can register it, and registration is optional. So there are a lot of people who are startup communities, and they would want to save because they're on shoestring budget. So they would want to save every penny that they can. And so they say that, well, if I don't have to register a trademark, why are you forcing me to register the trademark? So trademark registration is very important because once the mark is registered, you have special rights. There are special rights that come to you, and these rights are very high rights. For example, when your trademark is registered, you don't need to prove to the court that there is confusion in the market. So you don't need to bring evidence of market survey, nothing. Once your mark is registered, the court will take it as it is, and the defendant will be asked to change his mark. On the other hand, if your trademark is not registered, then the defendant will be, then you have to prove that there is confusion in the market. You have to argue that, look, the defendant has got a mark which is very similar to my mark, and it is likely to cause confusion. Look, this is the way he is trading in his business, and he has got other elements which are different. I will give you an example. For example, if Haldiram is not a registered trademark. So Haldiram, if you remember, is written in a very stylized manner with a red background. Now, if you take the same Haldiram, instead of calling it Haldirams, you call it Haldiram with a SSS or something else, some change, small little change, and instead of a red background, you make it a blue background, you change the font, you change the style of writing, you put some flowers and everything else. Then you will come to the court and say that, look, I'm not using the same trademark, and I'm also not using the same background. So therefore I am different. That's one of the things that a lot of people do. If it is a registered trademark, none of these defenses will work. So that's the importance of a trademark. Once the mark is registered, then it is no longer possible for you to take any of these defenses. That, I have changed the background, my color is different, my font is different, I'm using it for different goods. You're registered for bhujia, whereas I'm making sweets. These are not excuses, these are not defenses that would be tenable in a court of law. You can't have those kind of defenses. So that's why the registration of a trademark is utmost important. Now, going further, when you're choosing a trademark, that is also very important. What sort of trademark you choose is extremely important. Now, you may choose a trademark which is very similar to somebody else's trademark, like you have Uhu stick. So you choose a mark which is called blue stick. Then obviously there will be confusion, and this mark will not go through. If it goes through the registration process, you will have a problem with the courts, because the courts will say you are infringing. So therefore it's always good to have an invented mark, a mark which is not existing in the world. It's better to have a mark which is a completely new mark, which does not exist in the dictionary at all. So Zycadia is a new mark. It does not exist in the dictionary. It's not a dictionary word. It's not a word that you've actually heard of. So it's a very good mark to register. But when you actually want to register a mark, there are a lot of people, the businesses, the way they look at it is, they want to have marks which will describe their product. So if someone is having stationery, books, so they want to have something to do with books. So they choose marks which will describe the book, or they choose marks which will describe the business that they are in. So if you have a cream which makes you look very fair, then the natural tendency is to have a mark which says, okay, apply the cream and you will become very fair and very lovely. So it's a fair and lovely. So it's a descriptive mark. It's okay. Over the years, today Fair and Lovely has become a very big brand. So that's a different thing. But on the day when it was actually adopted, on the day when it was actually used for their business, it was a very descriptive mark. Now I will give you another example. This also could be a good trademark that you can take. For example, you have wine and spirits. Old monk. Old and monk are both words which are in the ordinary dictionary. But old monk, the combination of the two words, and for a completely different, completely arbitrary kind of goods, that is wines and spirits, is possible. So if you choose an arbitrary name, and if that name has nothing to do with the character of the goods, it has got nothing to do with the style of the goods, then also you can register the mark. Because when you think of old monk, nobody thinks that old monk is actually going to be something to do with anything of wine. People will think old monk is perhaps some old monk, some book or something. Nobody will associate it immediately with the books, with the wines and spirits. So therefore that arbitrary words chosen for a particular category of goods is also possible. I'll give you another example. Like you have cherry blossom. Cherry blossom. When you say cherry blossom, somebody will think, well, there are cherries, they are blossoming. Maybe it will be something to do with sauce. Maybe it will be something to do with jams, jellies. But no, it is with shoes. It is with shoe polish. So it's a totally different from the connotation of the word. So the words have nothing to do with the character or the type of the goods. Or apple. Apple, when you think of apple, you may say, okay, maybe this is something to do with fruits. But on the other hand, when you see the goods, the products for which it is adopted, it is computers, electronic goods. Totally different, has nothing to do with apple at all. So though you may adopt a word which is a common word, which is in the dictionary, but if it has nothing to do with the character, with the type of goods, then also you can have that kind of a mark. Or you can have foreign words, you can have Sanskrit words for a particular mark, for a particular type of goods. So those are also good. But if you have descriptive marks, that's where you have a problem. Like you have expert, or you have, as I said, Fair and Lovely is the best, or a vacuum cleaner, vac cleaner. So that's not a good description, because vacuum cleaner and vac cleaner, when you think of vac cleaner, it means that perhaps you're referring to goods. The goods are vacuum cleaner perhaps. But when you see the goods, yes, they are vacuum cleaner. So it is descriptive, and these kind of marks are generally not allowed. And even if they get allowed, and if you get registered also, you will find it very difficult to enforce these kind of marks. These are very difficult to enforce, because the defendant will come and say, vac and cleaner, vacuum is a word in the dictionary, cleaner is a word in the dictionary, and I'm using the dictionary word, so you cannot stop me from that. Now I will give you another example. Like you have, suppose the mark is woodland for say timber, and people sell wood in the market, so the raw wood which you buy in order to make furniture and all, and suppose you call it woodland. So somebody else will come back and say, all right, I'm not making woodland, I'm making timberland. And timber is a word in the dictionary, so you cannot do anything about it. So you will have a difficulty in enforcing it. Someone else will come with furniture land, and you will have a difficulty in enforcing your mark. So these kind of words which are descriptive are difficult to enforce, and these are definitely not recommended. Or you have, for example, somebody comes with red lips for lipstick. Red lips for lipstick is very descriptive, so this again will not work. So we will have to come with a mark which is a different mark, which is a mark which is nothing to do with the character and the type of the goods. Registration in case of a trademark is not very difficult. It's quite easy to register a trademark. You must register not only for the word mark, that means just the words. So there are different kinds of registrations that you can go for. You can go for just the words. So if you have, say, Haldiram, so just the word Haldiram, that can be one mark. Then you will also go for the style of writing. So that's the device. So you will go for the device as well. And then perhaps, at the background you have a certain color. So you may wish to go for the color as well, because color also can be trademarked. Because wherever anyone will see that Haldiram, which is written in that red color, in that red manner, and people will think that this is Haldiram. So you don't want anyone else to adopt that color and the combination of colors. So that also is registrable. So once you file for that, the mark, then the mark gets examined by the trademark registry. The trademark registry will issue a notice to you asking certain questions, and once you have answered those questions, perhaps they will also do a search, and they will see if there are any other marks which are similar to that. And once they have seen that, and once you find that there are no other marks which are conflicting with your mark, then your mark will get registered. But after the mark is accepted, then it will be advertised, so that the public at large will be able to oppose it. And once the opposition period is over, there is a period of about 3 months plus 1 month for you to oppose the trademark. And once there is no opposition, then the mark will proceed to registration. And so this whole process can be completed within about a year, not more than that. And in these days, in the current scenario where there are a lot of examiners, we are finding that the trademark registry is able to process our applications very quickly. And there are many times when we have found that the marks are registered in less than a year. And once your trademark is registered, then you have a very good right. You will get a final certificate. So as startups or as small businesses, as industries, the filing of a trademark is the start point. So there are a lot of people who will file and forget, which is very bad, because you must complete the entire process. Take the trademark registration certificate in your hand, and that is when the process is complete. Filing is only the starting point. And now once you get your trademark registered, then it is also an important thing for you to keep an eye on the market to see that no other person is copying your mark or using your mark for a business which is similar to your business, or for another business which is likely to hamper your business. So that is another feature that you must look out for. And then you can enforce your trademark. How do you enforce your trademark? You can enforce your trademark by going to the court of law and filing a case. All the time, it is not always necessary for you to file a case. It is also possible for you to simply send a cease and desist notice to the other side, to the infringer. And perhaps sometimes there are times when the company is a very small entity, and they may decide not to actually contest your trademark. and they may give up. But for those who do not give up and who are contesting your trademark, then you need to go to the court of law and you need to enforce your trademark. Now, how does this? There are two different kinds of categories of infringement, which I would like to bring to your attention. One category is those who are using your registered trademark for the same goods and making it in the same way. So, if you have registered it for, say, lipstick, you have registered Color Bar for lipstick, or you have registered Lakme for lipstick, then the other company is also making Lakme and he is also making for the same thing, that is lipstick. So these are counterfeits, and the court looks at counterfeits with a very heavy hand. You will find that the Delhi High Court has passed lots of strictures and lots of directions, lots of orders have been passed against counterfeiters. There is no sparing of the counterfeiters. So that is very easily enforced. Then comes another class where people are using a deceptively similar mark. So the mark is not directly the same. So they don't use the same Godrej or the same Hawkins or the same Lifebuoy or something. They don't use that. But they use a mark which is slightly variant. So it is a different variance of the same thing. So instead of Hawkins, it will be Hakins, Hawkins. Hawkins. Or if you have Boost, it will just say Boots, Boots. So it is deceptively similar. So those are the kind of, so even those are not possible. You cannot have registration, those kind of registrations, and the court looks at them very differently. The court does not encourage these kind of marks, and whenever you file a case in respect of these kind of marks, the court will injunct them and stop them from using those marks for the goods. Then you have another category of people who will be using the marks not for the same goods but for different goods. So if you have, for instance, Lifebuoy, Lifebuoy is the soap, but there will be a bunch of people who will take the Lifebuoy, the mark, and they will use it for socks. So you often find in the market, you get Wildcraft for bags, and then you get Wildcraft t-shirts. The company may actually be not making all of these things, but there are these people who are counterfeiters, and they make all these kind of counterfeiting products. So these kind of products are also, these kind of activities are also injuncted by the court. The court looks at them in a with a very heavy hand. The court has come down on these kind of variations. I can give you some other examples. So, for instance, we had a case where you have Lifebuoy. Lifebuoy was the brand which is owned by Procter and Gamble now, and this brand was being copied by another company, and they were making a soap, nothing else but a soap, which is called Likeboy. So Lifebuoy and Likeboy, and the court injuncted them because it is phonetically similar. So the defendant came and said that, look, why are you having a problem? Likeboy is different from Lifebuoy, and it's totally different. So how can you even stop me? The court said that no, it is phonetically similar. That is, when you pronounce Lifebuoy and you pronounce Likeboy, there is not much phonetic difference between the two, and for that reason the court stopped them. Then you have another case which I can tell you about is Flipkart. There was another website which was started by a bunch of people, which was called FlipkartLuckyWinners.com. This website was one where they were announcing lotteries, and they were having games. So you would have the game was that you have to choose certain books, and if you choose the correct book, you will get a prize, and that's why the whole website was called FlipkartLuckyWinners.com. Flipkart filed a case against them, and the court came down very heavily on them, and they were injuncted, and they were asked to remove the website flipkartluckywinners.com. Then you had another case I can give you. You had Hotel Panchavati. So there was another hotel which started, which said Sharma's Hotel Panchavati. So again the court said that this is again not a good trademark, and court said this was an infringement, and the defendant was asked to change the trademark. Other case could be, for example, Surf Excel. So Surf Excel, is a very big brand of soap, washing soap, and there was another person who came in the market, and his brand was called MR Excel and Surf Excel. And then when Surf Excel went to the market, the court said that yes, this is an act of infringement, and they were asked to remove they were asked to change the mark. MR Excel was asked to change the mark. Similarly, we had cases like you have Make My Trip. So Make My Trip, is a very famous website where you can go and book your tickets, and you can, you can do hotel bookings, you can do ticket bookings for aircraft, etc. There was another website which started, which was called MakeMyPravas.com. So that's very similar to Make My Trip. So when Make My Trip went to the court injuncted Make My Pravas, and they were asked to pay a lot of damages also to the court. So that was also injuncted by the court. Then India Today and Bharat Today. So there was India Today is a famous TV channel. Of course, it is also there was a magazine as well, and there was someone who in a remote place started a kids magazine which was called Bharat Today for kids. So Bharat Today and India Today, the court held is very similar, and the court asked Bharat Today to remove and change their trademark. Another example that I can give you is of Raymond the Complete Man. So there was another company that started similar kind of goods, Raymond the Handsome Man. And on this also the court granted injunction, and the court said that this is also an infringing material, and therefore they were asked to change their mark. So as you see, from all the examples that I've given you, courts come down very heavily on marks that are similar or identical. And once the mark is registered, there is very little that you have to go and prove in a court of law. So registration is extremely important. Not registering a mark will do you a lot of, will make it very difficult for you to enforce your trademark. Not that you cannot enforce it, you can, but you will have a lot of difficulties in enforcing your trademark. And there was, even Max Hospital had this trademark problem. There was someone, Max Hospital obviously is a very famous brand of chain of hospitals. There was someone who came up with a chain of, they were starting a chain, and it was called Max Cure Hospital. And the court said that this is of course an infringement of the Max mark of Max Hospital, and and Max Cure had to change their name. So therefore, as I was saying, once the trademark is registered, you have very high rights. The court recognizes you, and you have rights which you can enforce in a court of law, which are very high rights as compared to those times when you don't have any rights as a person who has not registered a trademark. When you have not registered a trademark, then you have to go and prove to the court of law that there is a confusion in the market. There are many things that you need to prove which you don't need to do when a mark is already registered. So with that, we come to the end of today's session. And if you have any questions, you can always post it, and I will be happy to answer the questions.
Right.